Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about murder and hearsay. Cases that should have gone to the Supreme Court of Canada, but didn't. Mr. McMorris was charged with a murder. In the course of being charged with the murder, there were other individuals who were also charged, one of whom pled guilty prior to the matter being set for trial in Mr. McMorris's case. The individual who pled guilty was alleged to be part of a group of individuals who committed this murder, including Mr. McMorris. But an individual in the jail overheard this person confessing to the murder and exonerating effectively Mr. McMorris. Mr. McMorris wanted to have this individual testify, but he refused to testify at trial. So Mr. McMorris applied to introduce the hearsay evidence of the confession in order to help exonerate himself, and the court dismissed the appeal. And this case raises very important issues in relation to hearsay evidence involving defense evidence. In cases especially involving individuals who have some liability for criminal conduct in relation to these types of investigations, it's very important for defense individuals to be able to put forward all of the events and all of the information that may help to exonerate them. And if the court is gatekeeping that function by calling it hearsay evidence without setting a proper process by which the admissibility of the hearsay can happen, then potentially innocent people are going to be convicted of murder. And although there are factors that can allow for the admission of defense evidence outside the ordinary rules of evidence, should they not be relaxed when it comes to hearsay evidence and individuals who are charged with the most serious crime facing the most serious sentence that we give in our justice system? It seems to me that the Supreme Court of Canada had an opportunity here to sort of weigh how the evidentiary rules should apply when it comes to evidence that is led by the defense that is hearsay. There are all sorts of exceptions to hearsay evidence in the Evidence Act that generally work to the benefit of the Crown. So why should there not be some exceptions at common law to hearsay evidence and the admissibility of hearsay when they work to the benefit of the defense? It's unfortunate the Supreme Court of Canada didn't see the import of this issue when it comes to witnesses who are potentially guilty refusing to testify. Hopefully this case goes to the Supreme Court of Canada in another issue, and the Supreme Court has the opportunity to deal with this question of whether defense can get hearsay evidence admitted in a different pathway with relaxed rules of evidence to protect one person's innocence. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.